So for the home, I'm guessing it's better to actually retitle to the trust rather than ladybird deed pour over. Not necessarily. There's actually lots of attorneys that prefer utilizing a ladybird deed, and our office utilizes the ladybird deed in this scenario all the time. I'll give you a few reasons of why attorneys sometimes prefer the ladybird deed option rather than retitling the home directly into the trust. The first has to do with homestead. Homestead is very valuable for many reasons. One of the reasons is the homestead tax exemption that can be applied for when you have homestead property. Now, there is language that can be put in the trust, and it should be in there when you have homestead, to preserve the homestead and the homestead exemption on any real property that's transferred into the trust. And there can also be language put in the deed that specifies that the homestead is to be maintained even though it's transferred over into the trust. But regardless of this, it's still a little up in the air as far as if it's always going to be accepted to be that way, or if every judge would agree on that in Florida. So because of that, a lot of attorneys just feel much safer leaving homestead property in the name or names of the people who are claiming the homestead and utilizing a ladybird deed that would put the property into the trust at the survivor's passing. Because either way, ultimately, it's going into the trust and it's going to be distributed under your trust. This also holds true with the 100% disabled veterans tax discount, which is 100%. So 100% disabled veterans don't have to pay property tax. And when you have a qualifying veteran, you might want to consider leaving their name on the deed, just in case there's any questions down the road as to whether the trust itself gets the exemption as well. So this would be also a good way to make sure that the exemption, the property tax, that 100% exemption is withheld during that person's lifetime. And then again, it just goes into the trust. Another thing I will say too that might be less likely, because really it shouldn't be an issue when you transfer property into a revocable trust, but because I have seen certain financial institutions and banks do strange things throughout the years and adopt strange policies, I don't 100% trust that every financial institution and every bank would agree not to call a loan due when it's transferred out of the person's name and into a trust when they have a mortgage. Again, could be unlikely, but depending on the scenario and depending on the interest rates or just sort of what's going on in the world at that time and specific things that go on within specific banks, it's not that far-fetched that by transferring your property into a trust, a lender might say, hey, the loan's due now, you transferred ownership. So that's another reason. Oftentimes when our clients have mortgages on their property, I will utilize the ladybird deed and leave the client's name on the property during their lifetime, of course, and then it can deposit into the trust upon their passing. These are a few reasons that the ladybird deed is sometimes preferred to transferring or retitling the property directly into the trust. Now, if you are going to retitle, I suggest you use a general warranty deed rather than a quitclaim deed. These are, of course, things that you should discuss with your attorney who's doing your plan. They should be able to enlighten you on the different types of deeds, why you would use them, and why you might prefer one over the other. If they can't do that, you probably want to look for a different estate planning attorney. So I hope this answers the question. If you have any other questions about ladybird deeds, revocable trust, estate planning in general, asset protection, probate, elder law, and you're in the Florida area, please don't hesitate to reach out to our office. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.